Jason, the contracting officer, and Charlie, the contractor, are in a dispute about whether Charlie's company should be reimbursed expenses incurred when he removed a rock so that he could install a running track as part of his government contract. Removal of this rock was not specifically described in his contract, and the government asked Charlie to remove the rock, which they expected to be very small, but ended up being very, very big. That's why Charlie believes it's his right to be reimbursed the $100,641 that his company spent removing the rock. In the last module, we watched Jason and Charlie go through the claim and request for equitable adjustment process to resolve their dispute. The contracting officer, Jason, approved some of Charlie's costs, and he declined some of the costs in his contracting officer's decision, and they negotiated a settlement. But what if Charlie was not so accepting of Jason's decision to decline some of his expenses, like the costs for his cousin Ramon? What if they used alternate dispute resolution techniques to resolve the cost elements in dispute? What is alternate dispute resolution? When should it be used, and how can it be used to resolve disputes? Alternate dispute resolution, or ADR, is any type of procedure or combination of procedures voluntarily used to resolve contractual issues in controversy. The objective of using ADR procedures is to increase the chances for resolving contractual controversies in a relatively inexpensive and a more expeditious manner than going to court. If Charlie were to appeal the contracting officer's decision, the appeal itself goes all the way to the Armed Services Board of Contract Appeals, ASBCA, or the United States Court of Federal Claims. If this happens, the parties will 1. Pay expensive attorney fees. 2. Spend lots of time preparing for court. 3. Process lots of paperwork through several levels of approval and clearances. 4. Then go to court missing and/or distracting from more progressive work they could be doing. Since both Charlie and Jason value their time, money, and work focus, they will attempt to resolve their dispute out of court using one of several methods of ADR. The most common methods of ADR include 1. Facilitation, 2. Mediation, 3. Mini-trials, 4. Arbitration, and 5. Using ombudsman. Click here to learn more about each of these. Facilitation. Facilitation involves the use of techniques to improve the exchange of information in a meeting between parties to a dispute. The techniques may also be applied to decision-making meetings where a specific outcome is desired, such as resolution of the dispute. The term facilitator is often used interchangeably with the term mediator, but a facilitator does not typically become as involved in the substantive issues as does a mediator. The facilitator focuses more on the process involved in resolving a matter. The facilitator generally works with all of the meeting's participants at once and provides procedural directions as to how the group can move efficiently through the problem-solving steps of the meeting and arrive at the jointly agreed-upon goal. The method of facilitating is most appropriate when 1. The intensity of the parties' emotions about the issues in dispute are low to moderate. 2. The parties or issues are not extremely polarized. 3. The parties have enough trust in each other that they can work together to develop a mutually acceptable solution. Or 4. The parties are in a common predicament and they need or will benefit from a jointly acceptable outcome. Mediation. Mediation is the intervention into a dispute or negotiation of an acceptable, impartial, and neutral third party who has no decision-making authority. The objective of this intervention is to assist the parties in voluntarily reaching an acceptable resolution of issues in dispute. Mediation is useful in highly polarized disputes where the parties have either been unable to initiate a productive dialogue or where the parties have been talking and have reached an impasse. A mediator, like a facilitator, makes primarily procedural suggestions regarding how parties can reach agreement. Occasionally, a mediator may suggest some substantive options as a means of encouraging the parties to expand the range of possible resolutions under consideration. A mediator often works with the parties individually, in caucuses, to explore acceptable resolution options or to develop proposals that might move the parties closer to resolution. Mediators differ in their degree of control while assisting disputing parties. Some mediators set the stage for bargaining, make minimal procedural suggestions, and intervene in the negotiations only to avoid or overcome a deadlock. Other mediators are much more involved in forging the details of a resolution. Mini-trials. Mini-trials involve a structured settlement process in which each side to a dispute presents abbreviated summaries of its cases before the major decision-makers for the parties who have authority to settle the dispute. The summaries contain explicit data about the legal basis and merits of a case. The rationale behind a mini-trial is that if the decision-makers are fully informed as to the merits of their cases and that of the opposing parties, they will be better prepared to successfully engage in settlement discussions. The process generally follows more relaxed rules for discovery and case presentation than might be found in the court or other proceeding, and usually the parties agree on specific limited periods of time for presentations and arguments. The third party, who is often a former judge or individual versed in the relevant law, is the individual who oversees the mini-trial. That individual is responsible for explaining and maintaining an orderly process of case presentation and usually makes an advisory ruling regarding a settlement range rather than offering a specific solution for the parties to consider. The parties can use such an advisory opinion to narrow the range of their discussions and to focus in on acceptable settlement options, settlement being the ultimate objective of a mini-trial. The mini-trial method is a particularly efficient and cost-effective means for settling contract disputes and can be used in other cases where some or all of the following characteristics are present. 1. It is important to get facts and positions before high-level decision-makers. 2. The parties are looking for a substantial level of control over the resolution of the dispute. 3. Some or all of the issues are of a technical nature. And 4. A trial on the merits of the case would be very long and/or complex. Arbitration. Binding arbitration involves the presentation of a dispute to an impartial or neutral individual, arbitrator, or panel, arbitration panel, for issuance of a binding decision. Parties may retain a particular arbitrator from a list of arbitrators to decide a number of cases or to serve the parties for a specified length of time. This is common when a panel is involved. A common understanding by the parties in all cases, however, is that they will be bound by the opinion of the decision-maker rather than simply be obligated to consider an opinion or recommendation. Under this method, the third party's decision generally has the force of law but does not set a legal precedent. It is usually not reviewable by the courts. Non-binding arbitration involves evidentiary hearings and presentations by each of the parties. Fact-finding assists in educating the neutral about the matter in dispute. After presentations, the neutral renders a decision. The parties are not bound by the decision. Ombudsman. Ombudsmen are individuals who rely on a number of techniques to resolve disputes. Usually, when an ombudsman receives a complaint, he or she interviews parties, reviews files, and makes recommendations to the disputants. Typically, ombudsmen do not impose solutions. The power of the ombudsman lies in his or her ability to persuade the parties involved to accept his or her recommendations. Generally, an individual not accepting the proposed solution of the ombudsman is free to pursue a remedy in other forms for dispute resolution. Alternate dispute resolution, or ADR, may be used any time the contracting officer has the authority to resolve an issue in controversy. Jason and Charlie may use ADR after Charlie submits his claim to Jason, or it can be used after Jason submits his contracting officer decision to Charlie. Jason verifies the 4 essential elements of ADR exist before pursuing of ADR. He verifies the 1. Existence of an issue in controversy. 2. A voluntary election by both parties to participate in the ADR process. 3. An agreement on the procedures and terms to be used. And 4. Duly authorized agents of both parties who possess the authority to resolve the issue in controversy. Jason is starting to think the use of ADR might be useful for resolving their dispute about the rock removal. So Jason talks to his supervisor. Jason asks, "What do you think about using ADR to resolve this claim?" The supervisor responds, "The contractor will need to agree to it, but since agencies are encouraged to use ADR procedures to the maximum extent practicable, let's do it." Jason asks Charlie if he would like to participate in ADR. Charlie says, "Yes, I would." So Jason and his supervisor contact their local legal office to get advice on how to begin the process. The legal office tells them they need a neutral. "What is a neutral?" Jason asks. A neutral is an individual who helps the parties to a contract to resolve an issue in controversy. It's a facilitator in facilitation. It's a mediator in mediation, and a conciliator in conciliation. You get the idea. A neutral shall have no official, financial, or personal conflict of interest with respect to the issues in controversy, and both parties must agree on which neutral they will use. "To get the process started, fill out this paperwork," says the attorney. "I will help you get started. We'll have to request location, date and time, type of negotiations, ground rules for the negotiation, confidentiality terms, the exact issues in controversy, choose a neutral, etc." After Jason and his supervisor complete the paperwork, Jason calls Charlie to work out some of the details to make sure both parties are in agreement about the terms of the proceedings and to make sure Charlie knows what is expected of him. Now that Jason and Charlie have agreed, the arbitrator holds an initial meeting. The arbitrator explains, "My authority and job as arbitrator is to 1. Regulate the course of and conduct the hearings. 2. Administer oaths and affirmations. 3. Compel the attendance of witnesses and production of evidence as I'm authorized by the law to do. And 4. Make awards. I will set a time and place for the hearings. I'll let you know the designated time and place not less than 5 days before the hearing. Hearings may be conducted on the telephone, teleconference, or by other electronic means if you both agree. You will both have the opportunity to be heard, present evidence, and cross-examine witnesses appearing at the hearing." The arbitrator then goes on to tell Jason and Charlie, "This hearing will be expeditious as possible and in an informal manner. At the end of the hearings, I will interpret and apply the relevant statutory, regulatory, policy directives, and evidence to issue a decision. I will make this award within 30 days after the close of the hearings unless we agree otherwise." And the arbitrator does just that. He holds the hearings, collects evidence, reviews relevant laws, regulations, policies, and contractual documents. He interviews witnesses and then makes a decision. During the course of the proceedings, the arbitrator finds out the rock that was removed was made of granite, and granite is a very heavy type of rock. It's about 2.5 times heavier than water. This particular granite rock was round, with no holes for lifting it out of the ground. This is what made it necessary for Charlie to seek a subject matter expert on rock removal. Now that the hearings have closed, the arbitrator will issue a decision within 30 days after the hearing or date of the filing of any briefs authorized by the arbitrator, whichever date is later. The arbitrator agrees with Jason that a private plane and a salary of $11,000 per day is excessive, but he does not find it unreasonable that Charlie hired a consultant to remove the rock. After going through all the findings of the hearing, the arbitrator issues the award, which includes a brief and informal discussion of the factual and legal basis for the award. He finds that Charlie acted reasonably on behalf of the government and incurred costs as a result. He decides to award Charlie an additional $2,000 for the plane ticket and $1,000 per day salary, and that includes all incidentals and his per diem. Total award, $6,000. The award in this arbitration proceeding will become final 30 days after it's issued to all parties, unless it is extended by one of the parties. If Jason and Charlie agreed, before the proceedings, that the arbitrator's findings to be binding, they will be bound by the opinion and finding of the arbitrator. However, if they wanted more control over the final decision, they may have elected to conduct non-binding arbitration. Assuming Jason and Charlie just went through non-binding arbitration, they may appeal to a higher court, which will be the next training module, appealing the final decision.